A Florida State Court of Appeals has just ruled that the Alachua County mask mandate, which was upheld by a circuit court judge last year, although it has been subsequently terminated by Ron DeSantis, was actually presumptively unconstitutional. And they've remanded the case back down to the circuit court to be reheard with the understanding that it is presumptively unconstitutional. Now, since the mask mandate has actually been removed, there's a question over the status of this case, and that part's a little bit weird, but the victory here is recognizing that the mask mandate itself violates the Florida state constitution, and it may provide an avenue for other challenges to other mandates in Florida and elsewhere under state, if not federal constitutions. Although I think the reasoning here applies to the federal courts as well. But let's talk about what happened and the actual kind of spicy fight back and forth between the appeals panel with the two-judge majority fighting with the one-judge minority. It's a pretty interesting back and forth. Let's take a look at it. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, make sure you hit that like button. Go ahead and click subscribe and make sure you turn on your notifications so you don't miss the next video. You almost missed this one. Let's be honest. All right, let's talk about this. So here we go. This is from Wink News, and the link to this article will be in the description if you want to check it out on your own. Okay, so divided Florida appeals court targets the mask requirement, pointing to privacy rights. A divided state appeals court Friday overturned a circuit judge's decision last year that allowed Alachua County to keep in place a mask requirement to try to prevent the spread of COVID-19. Now, this is a really interesting ruling because it looks to the privacy rights of the person who is being required to wear a mask, and it compares them interestingly to the mandated privacy rights afforded to women seeking abortions. They are saying that a mask is a healthcare decision and that the Florida Constitution mandates that that privacy right be held to strict scrutiny, that it is an enumerated and pronounced right, and that that right is implicated by the mask mandate as a healthcare decision, in the same way that abortion restrictions are healthcare decisions. And so it goes to this right of privacy. I think this is hilarious, and this is a great way to go ahead and use those abortion privacy privileges in a way that actually broadens the scope of that privacy right outside of the realm of women who want to abort babies. Because really, the privacy right recognized in Roe versus Wade and then recognized down in state courts tends to only apply to women who are pregnant and want to terminate that pregnancy. That is the only place that that privacy seems to have any level of legal import. Not anymore, according to these appeals judges. So let's take a look at some of the back and forth that they had in this case, because I find it kind of fascinating. And I'll give you some of my thoughts on each side's argument here. So the trial court simply looked at the right asserted by Green too narrowly, relying on the wrong privacy jurisprudence, said the 13-page majority opinion written by Judge Adam Tannenbaum and joined by Judge Robert Long. The right to be let alone by government does exist in Florida as part of a right of privacy that our Florida Supreme Court has declared to be fundamental. The Supreme Court has construed this fundamental right to be so broad as to include the complete freedom of a person to control his own body. Under this construction, a person reasonably can expect not to be forced by the government to put something on his own face against his will. Florida's constitutional right to privacy then necessarily is implicated by the nature of the county's mask mandate. And you can see what the judge is doing here if you're familiar with how abortion law works. They're borrowing the exact type of expressions that are used to justify the right to privacy in abortion decisions. This idea of complete bodily autonomy and not being able to infringe on that absent strict scrutiny. There's always exceptions in the Constitution because, frankly, the courts built those exceptions in themselves. But that being said, strict scrutiny is what they're saying. The underlying court, the circuit court, used what's called a rational basis test. Is the government mandate rationally related to a legitimate government interest? That's all. That's rational basis. And the government almost always wins on a rational basis test. But since they're saying that the Florida Supreme Court has declared the right of privacy to be fundamental, we go from a rational basis test all the way up to strict scrutiny, which means that the government has to have a compelling government interest, and the mandate or law or whatever must be narrowly tailored to further only that government interest and not sweep up otherwise constitutionally protected activity, not infringe on other lawful behavior. That would be a violation of privacy rights. So in this case, they're saying that the mask mandate is too broad. It is not narrowly tailored, or they don't actually go so far as to rule it unconstitutional. They say it's presumptively unconstitutional and needs to be tested under strict scrutiny. And under that test, the government will have to argue that the mask mandate itself is sufficiently narrowly tailored to achieve the legitimate government purpose, or the compelling government purpose of reducing COVID-19 infections. So first, the Florida government has to prove that reducing those infections is a compelling government purpose, and then they have to prove that this mask mandate is sufficiently narrowly tailored to actually prevent those infections. And the mask mandate is almost guaranteed to be overbroad. You have masks, you had mask mandates outside in open air places. You had them not really considering the size of the venue you might be in and stuff like that, or the fact that some people might have various exemptions or whatever. There were all sorts of contemplations left out and angles to attack this thing. Now, since the mask mandate has been removed, this case may end up being moot on remand. And that leaves it in an interesting place where the appeals court has issued a ruling and the remand will then be dismissed because there's no more need for the controversy because the mask mandate is gone. And so in that case, the appeals court decision will likely just stand. But the minority opinion is sharply critical of the majority decision. And so here, and I'm going to disagree with the minority opinion here. This is from Judge Joseph Lewis. He says, a person's privacy right is not absolute and is not to be considered in isolation without regard for the circumstances under which the right is asserted. Sort of. I mean, because technically rights aren't absolute so long as strict scrutiny is followed, he's kind of right. But let's read on, and I'll get to my big disagreement with this guy. He says, as the trial court aptly stated, so he's saying the lower court, a person's right to be let alone is no more precious than his fellow citizen's right not to become infected by him with a contagious airborne and potentially fatal virus. This is wrong. This is absolutely incorrect. Your right to privacy from government far exceeds any right you may have to not be infected by an airborne virus carried by a fellow citizen. That's actually not a right that you have. Trust me, I don't want anybody to get infected, but you do not have some constitutionally protected right to not be infected by a virus from your neighbor. That's not a thing that exists in any state, in any law, or under any government. One, it's an impossible thing for them to guarantee. And two, your neighbor who is sick is not a state actor or a quasi-state actor and cannot be bound by such constitution. Therefore, you do not have a right. There's no one who could be implicated in the right. I guess you could say you have a right to be free from government intentionally infecting you with an airborne virus, but that would be the government bringing the virus to you and infecting you. That's not something that's even at play here. You have to go to far circles of the internet to find those conspiracy theories. And I mean, while they're out there, that's not what's being asserted in this case or in really any of these cases going around. We're talking about going to a grocery store or going to a baseball game or whatever, and someone coughing somewhere and that virus getting to you and infecting you. You don't have a right against that. You've never had a right to not be infected. Your right to kind of try and avoid that is your right to stay inside in your own property and not be compelled to leave, which again goes back to your right to privacy and your right to autonomy over your body. You have those options, and you certainly have all of the options in the world to wear a mask to attempt to prevent infections or to get a vaccine to attempt to prevent infections on yourself. The government does not have a right to do this because we have privacy rights that supersede their ability. Now, the government says that they can go ahead and make this case and that they could win it if they needed to. They could prove out the compelling government interest in preventing infections and show that the mask mandate was narrowly tailored. I don't know that they can. Strict scrutiny is an extremely high bar. More importantly, I don't think they should be able to do that because I believe that the right to be left alone by government is far, far more important and far more protected than any other pretend right that Judge Joseph Lewis made up on his own to justify his argument. But why don't you tell me what you think down in the comments below? Until next time, we're mask free, apparently. Peace. Peace.